Attorney General as a
Did you talk to Stephen Miller?
I'm not going to describe the participants in conversations.
So you won't answer that question?
No, I will not, Senator.
Why?
I respectfully refer you back to my answer, Senator.
I am absolutely flabbergasted that you would come before this committee and refuse to tell us basic facts about a case that is at the core of but the quid pro quo that really concerns me is the one that brings you here today. You were virtually the only attorney in the Department of Justice willing to go to court and make a claim that career prosecutors said violated their basic standard of ethics. You were involved in purging prosecutors who, in good faith and an exercise of their prosecutorial judgment, they went to court, they brought charges, you purged them. Isn't that correct?
I don't agree with the use of the word purged, Senator.
Senator Richard Blumenthal accused Emil Bove of evading basic questions about the Adams case and raised a stunning conflict of interest concern. Was the dismissal connected to Bove's nomination to the federal appeals court? He then confronted Bove over the firing of prosecutors involved in January 6th prosecutions.
Mr. Bove, you responded to Senator Kennedy's questions about who was consulted about the dismissal of charges against Mr. Adams. Did you ever talk to Stephen Miller before you filed the memorandum on February 10th ordering the dismissal of the Adams charges?
Senator, I responded to Senator Kennedy's questions based on a publicly filed document that described the Attorney General as a...
Did you talk to Stephen Miller?
I'm not going to describe the participants in conversations.
So you won't answer that question?
No, I will not, Senator.
Why?
Because it is not appropriate for me to discuss...
It is appropriate for you to tell us whom you consulted before taking action on behalf of the United States of America. You have no basis to avoid that question, Mr. Bove.
Respectfully, Senator, I'm answering that question in a manner similar to several nominees before me, including Judge Katz's.
Did you talk to anyone in the White House, including the President, about dismissal of the Adams charges before the February 10th memorandum?
I respectfully refer you back to my answer, Senator.
I am absolutely flabbergasted that you would come before this committee and refuse to tell us basic facts about a case that is at the core of the challenges to the appearance of impropriety that should disqualify you. You have the opportunity to clear the air, to come clean with the American people as well as this committee, and you are evading and avoiding these questions.
On September 8th, 2025, Senators Sheldon Whitehouse and Richard Blumenthal renewed an ethics complaint against Bove with the New York State Attorney Grievance Committee. Their updated complaints cited additional allegations concerning his handling of the Adams case and other DOJ matters.
Senator, if you have a question about the position that I took in public with respect to the Mayor Adams case, I'm happy to address it, and I've addressed several today.
Well, I have asked you a question that bears on the appearance of impropriety. Let me go on. Mr. Bove, in court, you represented, first, that there was no quid pro quo, but you said that the decision, even if there were a quid pro quo, was unreviewable by the court. Do you stand by that?
I don't think that's what I said, Senator, because it's not consistent with the rule, which explicitly provides...
Well, you said it not only once, but you said it a number of times, and the judge observed, Judge Ho said, that your position was, quote, fundamentally incompatible with the basic promise of equal justice under law. That's what he said about your position, that the decision to dismiss these charges was unreviewable. Do you stand by that assertion?
I never made that assertion, and the judge granted the motion, Senator.
He granted the motion, but he disagreed with your premise that it was unreviewable. Let me ask you, are decisions to dismiss cases, as with that one, unreviewable?
The text of Rule 48 requires, in the instances presented by the Adams case, that dismissal only be provided for with leave of the court. That's as near a quote as I can give you. And the entire brief that I submitted acknowledged that point because we were seeking the leave.
The controversy did not end with this hearing. On July 29, 2025, the Senate confirmed Emil Bove to the U.S. Court of Appeals for the Third Circuit by a 50-49 vote. Two Republicans, Susan Collins and Lisa Murkowski, joined Democrats in opposing him. Bove was subsequently commissioned as a Third Circuit judge on August 20, 2025.
Mr. Bove, I am concerned about the quid pro quo that the judge concluded had been done. In fact, he said everything here smacks of a bargain. Everything here smacks of a bargain. But the quid pro quo that really concerns me is the one that brings you here today. You were virtually the only attorney in the Department of Justice willing to go to court and make a claim that career prosecutors said violated their basic standard of ethics. And the quid pro quo was a nomination to the Court of Appeals. That's the appearance that the American people can take away from your sitting before us with that nomination. And I think it does grave damage to respect for the rule of law, notwithstanding your assertions about your adherence to it, for you to be here as a result of that stand by you. Let me ask you about a separate issue, the firing of prosecutors and investigators who were involved in the January 6th prosecutions. You were involved in purging prosecutors who, in good faith and an exercise of their prosecutorial judgment, they went to court, they brought charges, you purged them. Isn't that correct?
I don't agree with the use of the word purged, Senator.
Well, you fired them.
I authorized the termination of probationary employees at that U.S. Attorney's Office, yes.
Because they prosecuted the January 6th rioters?
No, because I was concerned about efforts in the prior administration to embed those prosecutors as permanent employees at the U.S. Attorney's Office.
And you also fired the FBI investigators involved in the January 6th prosecution, correct?
No, that's not accurate.
You worked with Director Patel in firing them, correct?
No, that's not accurate.
The biggest verified development since this hearing is that Emil Bove was ultimately confirmed by the Senate to the U.S. Court of Appeals for the Third Circuit on July 29, 2025, by a 50-49 vote. He was commissioned on August 20, 2025, and is now serving as a federal appellate judge. The current federal judiciary records list him as a sitting Third Circuit judge. That makes Senator Richard Blumenthal's questioning particularly significant in retrospect. Blumenthal was warning the Senate about the appearance of a potential quid pro quo surrounding Bove's role in the dismissal of the criminal case against former New York Mayor Eric Adams and his subsequent nomination to a lifetime federal judgeship. Bove denied that characterization and maintained that his legal position was consistent with federal law. His written answers to the Judiciary Committee later emphasized that his argument concerned a dismissal being virtually unreviewable, not completely unreviewable. The heart of Blumenthal's questioning was simple. Who did Bove consult before ordering the dismissal of the Adams charges? Blumenthal repeatedly asked whether Bove had spoken with Stephen Miller, the White House, or President Trump before issuing his February 10th memorandum. Bove refused to identify the participants in those conversations. That refusal immediately intensified the exchange. Blumenthal's argument was that this wasn't an ordinary question about internal Justice Department deliberations. Bove was seeking a lifetime appointment to the federal judiciary, and the circumstances surrounding the Adams dismissal were already generating questions about the independence of the Justice Department. So Blumenthal argued that Bove had an obligation to provide enough information for senators to evaluate whether there was an appearance of impropriety. Bove disagreed. Rather than disclose who participated in the discussions, he repeatedly referred back to his earlier answer and said he was responding in a manner similar to other nominees. That frustrated Blumenthal enormously. He told Bove that he was flabbergasted that a judicial nominee would refuse to answer what he considered basic factual questions about one of the most controversial decisions of Bove's DOJ tenure. The confrontation then shifted from who Bove talked to what Bove actually argued in court. Blumenthal challenged Bove over his position in the Adams case that the government's decision to dismiss the charges was effectively beyond meaningful judicial review. Bove pushed back, saying Blumenthal was misstating his position. This distinction became important because Judge Dale, who had criticized Bove's argument in the Adams litigation, describing the government's position as fundamentally inconsistent with the principle of equal justice under law. Blumenthal therefore pressed Bove. Did he stand by his legal argument? Bove said that he had never made the assertion in the absolute form Blumenthal was attributing to him. His subsequent written answers to the committee reinforced that distinction. Bove said his February 2025 argument was that the dismissal was virtually unreviewable rather than completely unreviewable, and argued that the two positions were legally consistent. But Blumenthal wasn't satisfied. His larger argument was about the appearance of a bargain. Judge Ho had written that the circumstances surrounding the Adams dismissal smack of a bargain, and Blumenthal argued that there was another potential bargain that deserved scrutiny. Bove had taken an aggressive legal position on behalf of the administration and was subsequently nominated by President Trump for a powerful lifetime judicial position. Blumenthal therefore framed the issue as a potential quid pro quo involving Bove's career. That was an allegation, not an established fact, and Bove rejected the characterization. This distinction matters. There is a major difference between saying the circumstances create an appearance of a quid pro quo and proving that an actual quid pro quo occurred. Blumenthal was making the former argument during this exchange. The next major confrontation concerned the January 6 prosecutions. Blumenthal accused Bove of helping to remove prosecutors and investigators who had participated in January 6 cases. Bove rejected Blumenthal's description that he had purged prosecutors. However, he acknowledged that he had authorized the termination of probationary employees at the U.S. Attorney's Office. His explanation was that the concern was not retaliation for prosecuting January 6 defendants. Instead, he said he was concerned that the previous administration had attempted to make those prosecutors permanent employees. Blumenthal then raised another allegation, that Bove had worked with FBI Director Kash Patel in removing FBI investigators involved in January 6 investigations. Bove flatly denied that characterization. So the exchange ultimately became a clash over institutional independence, prosecutorial discretion, and political accountability. Blumenthal's argument was essentially, if prosecutors can be removed after pursuing politically sensitive cases, and if a senior DOJ official involved in controversial decisions can then receive a lifetime judicial nomination from the same administration, shouldn't the Senate scrutinize the circumstances extremely closely? Bove's position was essentially, his actions were lawful, his legal arguments were defensible, and the allegations were mischaracterizing his role. The Senate ultimately sided with Bove. Despite intense Democratic opposition, and despite Republican Senators Susan Collins and Lisa Murkowski voting against him, the Senate confirmed him 50-49. And the controversy did not disappear after confirmation. Senator Sheldon Whitehouse and Blumenthal later renewed a New York bar ethics complaint concerning Bove's conduct in the Adams matter and other matters. Their complaint alleged professional conduct violations. Bove has disputed the allegations. But institutionally, the most important fact today is straightforward. Bove is no longer a DOJ official or nominee. He is a sitting Third Circuit judge. The Federal Judicial Center records his confirmation on July 29, 2025, and his commission on August 20, 2025. That gives this hearing a very different ending than Blumenthal wanted. Blumenthal warned that the circumstances surrounding Bove's DOJ conduct could undermine public confidence in the rule of law. The Senate nevertheless confirmed him to a lifetime seat on one of the country's federal appellate courts. Bottom line, this exchange wasn't merely about the Eric Adams case. It was about whether a lawyer who made controversial prosecutorial decisions under a presidential administration could later receive a lifetime judicial appointment from that same administration without creating an unacceptable appearance of political favoritism. Bove's answer was that his actions were legally defensible and that Blumenthal was misstating both his legal position and his role in the personnel decisions. Blumenthal's answer was that the Senate had a duty to investigate precisely because the circumstances raise questions about independence. The Senate ultimately chose confirmation, And that makes the most powerful question for viewers today. Did Bove's confirmation prove that the Senate found the allegations unconvincing, or did it show how difficult it has become to separate prosecutorial decisions from political loyalty in a highly polarized Justice Department?